Urvashi further wants to know what is the difference between notice served and rule served. Many young advocates, junior advocates, in the initial days of their practice do not understand these finest things. Now, for a more better understanding of whatever I'll be explaining now, I suggest to you to also watch one video of mine which I have uploaded on this channel about rule nisi, what means rule nisi and all that. But still I'll answer your question here so that this answer also becomes a complete answer in itself. Now you see, whenever High Court hears a matter, a fresh matter, it first assesses whether the matter has any worth, whether the matter has any merits, so that the High Court can enter into the detailed hearing of it. That is called final hearing. So to assess whether the matter is worth admitting for final hearing, court first hears it preliminarily, at motion stage, and that is called admission hearing stage. So till the matter is actually admitted by the High Court, either by issuing an order of admitting it or by issuing rule, the hearing that continues is at the admission stage. Now see, a fresh matter, when listed for the first time before the High Court, on the very first day, High Court may not find any merit in it. It may find that the matter is totally worthless, totally meritless, totally without any substance, not even worth issuing notices to the other side. So it is possible that if the High Court comes to this conclusion on the very first day of hearing, the High Court may dismiss the case on that day itself. And on that day, then the matter gets disposed of. Nothing remains in that matter before the High Court. That is the first possibility. A second possibility is that after hearing the matter for the first time on the first day by the High Court may think that yes, there is some substance in this matter. There is some worth in it. Such worth that the other side needs to be heard. The opposite side needs to be called for answering whatever the points that are raised in the petition. But at the same time, the High Court doesn't come to a final conclusion that this needs a detailed final hearing. The High Court only wants to know the viewpoint of the other side before actually admitting the matter for the final hearing, which will be the third stage. So at second stage, what the High Court does is simply it issues notices to the other side, meaning that these are notices before admission. It is commonly called NBA. I do not know what is the practice in Gujarat High Court, but here in my court, the Nagpur bench of Bombay High Court, this practice is very much prevalent. NBA means notices before admission. Now the practice that has grown is simply to write notices, issue notices. One has to now understand that the court means that these are notices before admission of the matter. So that is what the meaning of notices is. Now whenever the court issues this kind of notice, and when the notice of the court is served through the process of the court on the other side, and a report of that service is given by the bailiff, or maybe the parties themselves serve the other side by taking hamdast, and a report to that effect is given to the registry of the High Court, that is when is called notices served. Now coming to the third stage, as I explained to you some time before, if after hearing the parties at the admission stage, the court comes to a conclusion that the matter is so important, it raises so important questions that they need to be gone into great detail by hearing the parties at the stage of final hearing, the court may issue what we understand as rule. Rule means admit the matter for final hearing. Now, after issuance of notices, whenever the parties are served, and again the matter is heard at admission stage, the court may come to this conclusion that this needs to be admitted for final hearing, and then the court issues rule. Again, the parties are required to be served with the order of rule. So, unless and until a report of service of rule or the order of admission of the matter is received back, it cannot be said that the parties are served on rule and the matter will not proceed. Understanding? Please understand that there is first service at the time of issuance of notices. And after admission of the matter for final hearing by issuing rule, there is again another service to be effected upon parties of that order of rule. And that is what is called service of rule upon the other side. So both these stages are so important that the parties are required to be put on notice. Firstly, that you are called upon to answer the petition at the stage of admission. And secondly, please be prepared for detailed final hearing at the time of issuance of rule. After issuance of rule, the parties are also free to file a detailed answer to the petition, which is commonly known as a return. A return is always filed in response to rule. See, I am explaining so many side things also with regard to this question. So please understand that while I am trying to remain on track, I may go some off track just to answer the related things in that question. Okay, so that is the difference between notices served and rules served. I hope the answer is clear.